years ago, and that was very helpful in trying to address sexual harassment cases in the workplace, many of them involving rape, and largely overwhelmingly immigrant victims. So what we're seeing is that the workplace is a place where domestic and sexual violence has a great impact on the employees. So when they're at work, they can't be productive. Sometimes the abuser comes to the workplace, and sometimes the employee needs protection from harassment while at work. And this might be harassment not only by her spouse, boyfriend, whatever abuser, immediate abuser, but oftentimes in the workplace, most of the sexual assault threats will come from a supervisor or co-worker. So we want to take you through the protections that they have, and then also what kind of accommodations she may be able to seek at the workplace. So there's definitely a correlation between domestic violence and workplace sexual harassment. Just among farm worker women in particular, a study was conducted among them in California, and they all said the two main problems they faced was domestic violence, and after that, sexual assault at work. And when I talked to some farm workers, I said, well, what do you mean by sexual assault at work? They principally addressed it was rape in the fields, where women had to either have sex with a supervisor in order to get a job or to keep a job or to get a promotion or to get another relative employed. And then they were fired if they refused to provide sex. So these are kind of some of the similar cases that we've been having to deal with. Now, in domestic violence, though, historically what has been the target for reform has been to have criminal law enforcement and to also get the courts, judges to make sure that abusers are targeted, arrested, locked up, whatever. And then secondarily, sometimes was the issue of how do you help the victim heal or be in a safe place. In sexual harassment law and in civil rights enforcement, the target is the company. We target the company because the company is the entity that controls the conditions of work. So they can make the necessary changes, or they're supposed to be able to make the necessary changes, and then they can provide the money to make the victim whole. So federal civil rights law provides for money for victims. But, very similar is that the violence control and balance of power is the same. So in domestic violence, usually the power imbalance has the husband controlling many things because he may have the job, he controls immigration status, etc. There, the remedy, though, is generally conviction and trying to find safety. There's no real money that the victim gets. In non-work-related sexual assault, somewhat similar. There's a conviction. There may not be much money unless there's some kind of Victims of Violent Crime Act. And if there's some kind of tort action against the perpetrator, that usually doesn't leave much money. Usually the perpetrator doesn't have much money anyway. In sexual harassment, I think the power imbalance is greatest here because the employer controls all the conditions of work. He can determine whether Maria eats or not, has a roof over her head, whether her kids can eat or sleep. They can try to arrange for her deported, all of these kinds of things. But fortunately, there is a remedy that the law provides for, which can include money for the victim, termination of the harasser, and trying to change the company's policies. So one of the things that we have in the United States that is a complete aberration to every other country around the world is that we have a law that prohibits discrimination on the basis of race, color, sex, national origin or religion, and disability and age. And we have the Equal Employment Opportunity Commission, which was created by the Civil Rights Act of 1964. And what we're able to do is investigate complaints of discrimination. Employers have to cooperate with us. And if necessary, we have to file lawsuits. So this is a very radical law when you look at the body of laws in the United States. It's a law that most people don't know fully enough about, but it is a good instrument to use in protecting victims of violence. So Title VII of the Civil Rights Act, which we enforce, covers nearly every worker providing there's 15 or more employees. But I want to target something here, which is undocumented workers are covered by our law. I litigated the case. I co-represented Alicia Castrejón in a case that the EEOC had brought, where the issue is whether undocumented workers in a pregnancy discrimination case, whether they're covered by the law. After the passage of the Immigration Act of 1986, there's a published decision that clearly says undocumented workers are covered by Title VII. Now, we can only cover employers with 15 or more employees. We can also cover unions if we want to do unions as members, but our principal target are employers that have 15 or more employees. What begins an investigation for us is whether somebody comes forward to complain. It can be the employee herself. It can be a third party. For example, a nonprofit organization can come forward and just say, Maria came to our shelter, Maria came to our office, and we believe that she has been a victim of sexual harassment in the workplace. And the third party can start what's called a third party charge. It gives notice to the EEOC that we can begin an investigation. The other way is one of the 5 commissioners in Washington, D.C., on his or her own initiative, concludes that there may be some discrimination going on at a certain entity and just directs one of the offices of the EEOC to start investigating. So our laws, as I briefly said, are pretty straightforward. They prohibit discrimination on the grounds that I mentioned, race, color, sex, etc. The ADA, Americans with Disabilities Act, requires reasonable accommodations, and I'll discuss that later on as it pertains to people who are victims of violence. So in straight-up Title VII cases, what we're trying to look at is somebody is treated differently based on their race, color, sex, an example in these cases based on sex. And the law makes it very clear that it's illegal to discriminate on the basis of sex. I mentioned here pre-1965. Just remember that before 1965, when Title VII went into effect, it was perfectly legal to discriminate against women, African Americans, etc., based on their gender, based on their race, and so forth. I throw in Mad Men in here because what some of the things that you see in Mad Men were legal then, but not legal now. So let's say a woman is working for a workplace and she's been subjected to domestic violence, and the employer says, you know, Maria, we just got to get rid of you because, you know, I just don't want to have so many battered women bringing all this drama to the workplace. That would be an example of discrimination based on gender. Or an employer says, you know, I'm only going to select a male applicant when he learns that a female applicant obtained a restraining order against a male domestic partner. Or excuse me, we'll hire only women because true victims of domestic violence can get restraining orders, whereas men should not. So it's kind of a little twisted example here. But he's working on a bias against male, relying on a male stereotype that male should not obtain restraining orders or don't need restraining orders, and so he's going to prefer a female. That's all examples of sex discrimination. Another case is where somebody is given, a male employee is given unpaid leave for a court appearance in a criminal prosecution, but the female employee is not given unpaid leave and is told, you know, if you're victim of violence, that's not going to be something I'm going to give you time off to testify on in court, viewing it as mainly a marital problem and so forth. That could be grounds for discrimination or unlawful discrimination. So the other part of sex discrimination is considered as harassment. So harassment is a variety of things, and I'll get into what that can constitute. But the perpetrator or the victims that can either be male or female, same sex, opposite sex, and the harassers can be the same or others, but it can include supervisors, agent employers, and importantly, third parties. So if a third party, like for example, the husband is coming to the workplace harassing the wife, the employer might be on the hook for not taking enough steps to make sure that the husband is not harassing the victim at work. Because again, the employer controls the conditions of work, not the employee. Victims can be somebody directly targeted, but it can also be somebody, for example, who hears or observes many aspects of a hostile work environment. The classic example is an African American employee who may hear, or let's just say a female who may hear other women targeted by sexually harassing comments, propositions for sex, etc. She herself is not propositioned, but she hears it and she sees it on a regular basis that it affects her workplace or work conditions, and consequently she's a victim of sexual harassment. For the EEOC, sexual harassment charges have been increasing significantly. Our overall charge numbers have increased from 76,000 to over 100,000, excuse me. And it's a consistently 12 to 13 to 14% of our charges are sexual harassment. So although there was a slight increase from 2008 to 2011, we do think that overall that means because of the economy and fear of retaliation that women were not complaining. So sexual harassment itself can be a variety of things. It can start from verbal matters, requests for sex, sexual advances, etc., certain comments, all the way to rape, other kinds of assault and battery. The law asks or checks to see whether the harassment itself is so severe or pervasive enough to alter an employee's working conditions, that it creates a hostile work environment. So what I used to illustrate this is we litigated a case out of San Jose a few years ago where women were working in a collections agency. Several women, about 20 women, were in an office, and the supervisor, a male supervisor, would constantly stare at their breasts, make comments about their breasts, and when a woman had to speak to the manager, he would invite her into the office, and he would make her stand up, but he would always be sitting down. He would always be staring at her breasts. At times, when he would enter the work area where most of the women were very scared, and if they knew he was coming, somebody would blow a whistle or make notice to everybody else, and all the women would grab a file folder and cover their breasts because they say, "Joe's coming." So in some presentations, people say, they laugh, and I say, well, why are you laughing? Because people say, well, is that sexual harassment? Is that a hostile work environment? And I say, well, if you have to do this like 4 or 5 times a day, times 5 days a week, times 4 weeks a month, times 12 months a year, it can alter your work environment because you can't even just do your job. You always have to be on the guard of whether this supervisor is going to come in and start staring at your breasts and making comments about you. So the test is whether a reasonable woman in that situation would feel that this was objectively a hostile work environment. So not everything's going to meet the test, but you have to look at the facts very closely. Employers can defend against sexual harassment, the hostile work environment harassment, if they can show that the employer took prompt and corrective action and that the victim failed to complain and take any preventive measures. So, for example, if a supervisor is harassing Maria, but Maria doesn't tell anybody about it, but maybe a third party finally gets around and tells the employer, and the employer says, okay, I investigated and I fired Joe. That may remove any kind of liability for the company. Similarly, when it's coworker harassment, so long the employer knew or should have known about the harassment and failed to take any prompt and corrective action, it could be liable. If it takes prompt and corrective action, then there may be no liability. Fuller versus City of Oakland is a key case that I think anybody who wants to understand this area should really review, because the facts here are that Fuller was a police officer in the City of Oakland, California. She was in a relationship with Officer Romero. They had about a 9-month relationship, and after a while she breaks it off. Romero doesn't get the message, and he's continuously harassing her, taunting her, stalking her, and when he sees, and she's complaining to her supervisors, they do nothing about it. And then the straw that breaks the camel's back is when she's driving down the road with a new boyfriend, and Romero sees them and tries to run them off the road. She tells her managers that this is a dangerous situation. Somehow before that, he had obtained her unlisted number, started harassing her, and so forth. So the management in the police department, what do? Instead of referring it to human resources for investigation, they turn it over to internal affairs. And no investigation is really done. They finally get served with an EEOC charge. Internal investigation starts to interview Fuller and her fellow officer who testifies on her behalf and says all this harassment stuff's going on. And then they issue a finding of basically saying that they don't believe her, and they never interviewed Romero. Officer Fuller then sues the City of Oakland, but by this time the harassment had stopped. Romero finally got the message and stopped harassing her. So she files her lawsuit, however, and the lower court says, well, since the harassment stopped, there's no more basis for the lawsuit. But Fuller appeals and says, no, it's not enough that the harassment stops. It's that the employer must also take corrective action. And here in this case, the Ninth Circuit points out, the City of Oakland never interviewed Romero, never disciplined Romero, and actually retaliated against the officer who was Ms. Fuller's witness. And so they said, in this scenario, there was no corrective action or prompt corrective action by the employer, and moreover that, they also have to show that they've deterred future harassment. And since they never disciplined Romero, there's no deterrence to Romero from coming back and harassing Fuller. So that case was remanded down to the district court, and I presume that they settled out. The irony in this whole thing is that Romero was promoted to captain even though he had never been disciplined. So another form of sexual harassment is the more classic one, which is where it's quid pro quo, where an employer conditions promotions, hiring, etc. on sexual favors. If this occurs and it's done by a supervisor here, the employer has no defense to quid pro quo harassment. It's what we call a tangible employment action, and an employer would be strictly liable for this kind of harassment. So some examples of sexual harassment may include somebody sitting, being harassed by her coworker who stalking her, waits for her outside the bathroom, sends personal emails, all these things at night, and she reports it to management. Management may transfer him to another area, continues to stalk her and makes advances, and she continues to notify management, but they take no further action. That might be liability for the company because she's continuously telling them that the transferring of the harasser has not stopped the harassment by any means. In a case that we're litigating right now, kind of similar facts, we have a case where a supervisor was harassing a female employee. Not only that, her husband was beating her up, and the husband also worked at the company. And the supervisor told the husband he should kill his wife, and that the way men control women is to make sure that they beat them up and keep them in line. So it was constant abuse by the male supervisor and by her husband, and the male supervisor condoning the husband's violence at work and at home. We are also litigating a case of male-on-male sexual harassment, where it's a whole climate of propositioning for sex, grabbing, showing their penises, all this kind of stuff. One employee basically had to feel like it was not safe and quit after he had been constantly complaining. So we also know that there are a lot of obstacles to reporting. And in our investigation, we're fully aware that if somebody steps forward to complain, she's jumped through a lot of hurdles. In many of our farm worker cases and in service industry cases, we have cases of rape, sometimes at gunpoint and sometimes with knives. So I want to refer you to a case we settled almost 2 years ago called EEOC versus Willamette Tree Company. And this is a case where the farm worker had been just hired, with she and her siblings had also been working at the place earlier. And on her second day of work, she's told to go to a room where others' machinery is, up in a little loft. And the supervisor takes her up there, and she sees cardboard boxes that are flattened out on the floor. And he proceeds to push her down onto the cardboard boxes, puts shears to her throat, gardening shears to her throat, and says, "I'm going to have you, and I'm going to have you right now." And he proceeds to rape her. And after that, he told her, "If you tell anybody, I'm going to kill you and your siblings who work here at the farm." And over the next 3-4 month period, during winter time, he forced her to go out in the fields in Oregon and perform oral sex on him. So for a long time, she never told anybody. How we found out about this was that her sister, Flora, had just been fired for complaining about sexual harassment. Although she had not been raped, she had been constantly propositioned for sex. She complained and was fired. She goes to the Oregon Law Center in Portland, or in just outside of Portland, and in the Willamette area. And she talks to the lawyers and says, "I've just been fired. I've been subjected to sexual harassment." And the lawyers at Oregon Law Center in Woodburn say, "Well, is there anybody else?" And she says, "Yes, I think something happened to my sister, but after she was fired, she's never been the same." And the facts of the case is the sister had stopped performing sex because her throat had been so damaged, oral sex had been so damaged, and then the supervisor had fired her after that. So Flora says, "Yes, there's my sister, Emmy." And so the lawyers say, "Well, bring Emmy to the office." So they bring Emmy, and for the first time, Emmy says, "Well, I should tell you, on the first day of work, this is what happened to me." She describes how she was raped and how she had been threatened. So this is the first time that her sister and her brother-in-law had heard about the rapes. And I use this to illustrate the fear and that she had in reporting this. So we did have a related problem then. She had missed her deadline of 300 days to report the violation to the EEOC so that we can investigate. Fortunately, there was a case out of the Ninth Circuit called Stoll versus Runyon, in which the Ninth Circuit says, in a similar case of a postal worker who was raped repeatedly and threatened with physical harm, and she missed her deadline to file her lawsuit, But we argued that this is a similar case, and there the Ninth Circuit had said she can continue her lawsuit because the employer cannot benefit from having traumatized her. We made the same argument in the Willamette Tree case, and fortunately the district court in Oregon agreed with us that if anything warranted equitable tolling, it was the facts of this case, because the harasser had threatened to kill her, and we had shown through a psychologist and a therapist that Emmy had been so traumatized by the rapes, multiple rapes, and the threats to kill her and her family. So we know there's obstacles, but if there's a time when somebody can't tell their story and they're not on time, we can try to figure out if there's a way we can still keep doing the investigation. In this case, too, and in other cases, we've also been able to get protective orders, particularly when employers are asking about immigration status during discovery. So I said earlier that undocumented workers were covered by Title VII, but employers will still try to ask about immigration status in order to deter or to chill her out from participating in the lawsuit. So we were able to get a protective order from the court in Willamette that prohibited any questions about immigration status, any questions into her prior sexual history, and any questions into her reasons for not reporting the rapes to the police. We were able to argue to the court that, we know that in most situations, women who are victims of rape never tell the police that they've been raped. So we said it's not going to be determinative of her credibility in one way or another. And the court bought the argument. He didn't want to chill her out. So when we investigate a case, so the employer will get served with a charge, and then we'll launch the investigation. In harassment cases, what we're really looking for is, did the harassment occur? Okay, we're technically a neutral fact-finding investigative agency during this stage. What things we're going to look at is whether the charging party, the victim, complained to the supervisor, the human resources, and what did the employer do once they found out this information. Critical for us is this a place where there's really nobody to complain to, that the top official is the harasser, or the top official or the harasser is not reprimanded or overseen by another company official, then it's pretty much free reign for that supervisor. Also, we'd like to also know is whether she has been threatened if she complained, or if she's told if she complains she'll be terminated or so forth. Those are critical issues for us. And then we also want to know, are there other victims? Because EEOC can determine whether there are similarly situated victims and get relief for them. So in EEOC versus Tamayo and Antle, this is a case we settled 14 years ago now, but this was one of our first big farm worker cases in which a farm worker had said that, in order to pick crops for the season, she had to have sex with the hiring official. She did, and then when she was further harassed, she protested and was fired. Well, we found out that not only she was a victim of sexual harassment, but other women were. We made a determination that there was a class of women, and we were able to settle that case for $1.855 million. In the American Building Maintenance case, this was a case involving janitors in the Bakersfield area. And we found that, many women had been sexually harassed, had been forced to have sex in order to get a job as a janitor or to keep their jobs. And we settled that case for $5.8 million. So the key here is, if you're interviewing somebody who may have been sexually harassed, sexually assaulted at work, always ask, is there anybody else? And if they tell us that there's maybe somebody else, we can always investigate and ask the employer for employer files, employee files, find out whether there have been any history of complaints against a particular supervisor, all this information so that we can make a finding whether we believe harassment has occurred. So in our investigations, we have the right to go on site to talk to a lot of company employees, and the employer has to make them available. We can subpoena their records, and if we investigate, or if we're investigating the employer's withholding information, we can enforce a subpoena in federal court, and then the enforcement of the subpoena makes the existence of the investigation public. And this is critical because unless the matter is in litigation, we normally cannot talk about a matter in investigation. Our general reply is we can neither confirm nor deny the existence of an investigation. However, if we issue if the federal court enforces our subpoena and orders the employer to turn over documents, our mere filing becomes a matter of public record. And if the court orders the employer to turn over documents or make people company officials available to us, I will issue a press release that says, Judge so-and-so told this company to turn over documents that it had been withholding in a federal civil rights investigation. So that way, everybody knows there's an investigation going on, and potential victims or witnesses can come forward and contact us. So how do you prove harassment? Isn't this all behind closed doors? And so what we have to figure out is the charging party, is the victim credible? Is she telling the truth? We cannot assume that she's lying. And those of you who have perhaps have done immigration law or political asylum law, the law is very clear that a federal agency cannot assume somebody's lying just because there's no third party corroborating her. Because we know that in most of these cases, particularly egregious sexual harassment, it happens behind closed doors, and there's no third party witness, no third party corroborator. So some of the things we're going to do to figure out her credibility is really observe her. Is she emotionally upset when she describes what happened to her? Is she crying? Now, we also know that in cases, particularly of egregious sexual assault, women react in very different ways. They can be stoic. They can have buried all this stuff. They're not emotional about it. And then it can go from that to somebody who's crying constantly and is really very emotionally upset, and it's so clear. But the way she reacts, at least in describing the story, is not going to be necessarily determinative. It's certainly helpful sometimes if she's crying, emotionally upset. That may illustrate that something out of the ordinary happened. Now, can she describe details, where she was touched, the frequency of the grabbing? All of that may be critical. It is kind of difficult, I know, in our cases where women cannot use certain terms or describe sexual sex acts. They may say things like, well, so Maria, what happened? She'll say, oh, I fulfilled my obligation. Basically, it was quid pro quo. But it's hard for her to get those words out, and that's a whole other workshop on skills of how to get this kind of information out from the victim. We will also ask her, what was said to you, Maria? What did he say? Did he threaten you? Did he say anything about what he wanted to do with you? Things like that. Critical is whether she's been threatened by the harasser, manager, coworkers, such that she was deterred from wanting to pursue it, or they made it a price for reporting as that she might be fired. If there's any physical injuries, if she went to the doctor, we would try to get all that medical evidence available. So all we're trying to do is every bit of evidence that helps buttress her credibility so that we can establish liability and damages. I mention here again the Tamayo and Antle case because this is a very difficult case to investigate. It's a matter where the charging party says, I was forced to have sex with the hiring official. So how do you prove that? That it's not welcome, that it's not consensual, that they're not just having an affair? And in that case, she said that the first time it happened was in Yuma, Arizona. She had been working about 2 or 3 seasons in a row. She was hired but never had to have sex. But this time she's told, well, Blanca, you got to do what all the other girls do. And she understood what that meant. And so she went with the harasser, or the hiring official, it was the harasser, hiring official. She went into his truck, and she described how they went to the truck. They drove to an ATM, he got cash, and then they went to the motel. And, and she was forced to have sex, and she had sex with him at the hotel and was able to pick crops that season. So we were able to send the investigator out to the bank in Yuma, Arizona, confirm that there was a withdrawal that day, which is a bit of evidence to corroborate her. And then we were able to show that at the motel he had signed in. And so now it's a bit of evidence to show that what she was talking about is accurate. It doesn't show whether it was consensual or not. They could have just been having an affair. So we asked her, well, the second time, what happened? Well, it happened in Salinas. My friend drove me to his house, and then I had sex with him. And so how would we show that this was unwelcome? And what we're able to do is talk to the friend who confirmed that, yes, I drove Blanca to his house, the supervisor's house. So we were a little stymied. So we said, well, how else could we show this? And I just had a hunch. I said, why don't you just have her draw the layout of his house? Because this is something that immigration agents do when they're trying to figure out whether a marriage is a fraud or not, whether someone's trying to get a green card. Just have them draw layouts of the house and see if both of them draw the same layout. So she drew a layout of the house, and she describes it and says, yep, here's the living room, here's the kitchen, here's the dining room, and here's the TV where my 3-year-old daughter was watching TV, and here's the bedroom. And then she broke down and cried hysterically. And so that indicated to us that something traumatic happened to her. Something out of the ordinary happened, which led us to conclude that this was not a consensual relationship. And we made a finding of discrimination and eventually got into negotiations with the company, and that led to the $1.855 million settlement. Part of proving harassment is also to find out, is the harasser credible? Maybe he's got a story. Does he have anybody who supports it? And we'll have to look at that. And then another critical piece, though, is, are there prior complaints of harassment against this individual? And if the company has records of these, we have a right to, as the agency, to go after this. Now, very commonly, they don't keep these records, or somehow they're missing or destroyed. And it's just something that happens. But what you want to know is, what did the company do once they were on notice that there's a problem with this harasser? Did they discipline them and so forth? And more importantly, are the company officials trained to handle the issue? You may have small companies or even big companies where the supervisor, a manager, HR, they don't know how to investigate these claims, or they don't know how to do a good investigation. So we will also go and interview other witnesses, co-workers, could be supervisors, people who may have the chance to look at things. We know that most harassment is not going to be observable because it's behind closed doors. If there are parents, sisters, whatever, who notice something out of the ordinary, as it was in the Willamette Tree case, their testimony could be very valuable in the investigation. In the Foot Action case, this was a case of a 17-year-old girl who was working at Foot Action in San Jose. This was her first job in high school, well, the first job ever. She was still in high school, and she was a very attractive young woman who the assistant manager would constantly proposition, say things about her body, and so forth. He was 18 years old. Tiffany complained to the manager. The manager really did nothing. It's just to tell the assistant manager, you know, just back off. But the assistant manager then threatened Tiffany and said, if you tell anybody, I'm going to complain. So the harassment stopped for about 3 weeks, and then it resumed again, and Tiffany reported it to the manager. And the manager then, you know, told the assistant manager, you got to stop doing this, you know, it's against the law. The manager, however, never took any real disciplinary action against the assistant manager because he was dating the assistant manager's mother. Subsequently, the assistant manager corners Tiffany in the back of the store, puts his arms around her neck and says, I told you, if you report me again, I'm going to break your neck. So she's scared, she's traumatized, and she goes home and she's crying, and her mother walks in the door and sees Tiffany curled up in a fetal position on the couch, crying. And the mother fortunately talks to her, and she tells the mother the story, and the mother brought her to the EEOC. And we settled that case, I believe, for like $125,000, $140,000 several years ago. But the mother's testimony was strong corroboration. It confirms that there was some kind of trauma, something out of the ordinary that happened, which corroborated Tiffany's story about being threatened after she had reported the harassment. Police reports. Again, you know, police reports, we know that police reports are only used in made in less than 10% of sexual assault crimes. And in a criminal case, you know, the standard is much higher beyond a reasonable doubt versus preponderance of the evidence in civil cases. I point to the EEOC versus Harris Farms case, which is a case my office litigated and tried in Fresno a few years ago. This was a case where Olivia Tamayo, a farm worker, was raped at gunpoint 3 times by her supervisor. After she had reported the rapes, the company did contact the deputy sheriff, and unfortunately she was threatened. The first time she was raped, the harasser, supervisor, says, if you tell anybody, I will kill your husband. He raped her in 93 and 94 and 95 and made the same threats again. As a result, she never told anybody. In 1999, the harassment again escalated, and she finally told the company about it. They eventually got the deputy sheriff involved, but the difficulty here was Olivia did not speak English, and the sheriff did not speak Spanish. And so the sheriff relied on the company's assistant HR director to do the translation, when she herself was not that fluent and was biased already, and told the sheriff, well, we think Olivia's lying. And so the deputy sheriff basically dropped it and said, well, yeah, I think she's lying too. Because the company had said, oh, you know, they've been having an affair for the last few years. Everybody knows it. It's been a rumor. Everybody knows that she and her supervisor have been having an affair. We were able to go to a jury, and in 2005, the jury said, we believe you, and here's $1 million. So the fact that the deputy sheriff concluded that Olivia was lying had no bearing on the jury, and had no bearing on us, and we thought that we could prevail, and fortunately we were able to do that. So we also know in the context of these investigations, it's really hard to, there's going to be a lot of hurdles, and part of those hurdles, you know, may be immigration status, fear of deportation, and a more common one is feeling that the spouse or boyfriend will beat her up and harm others if he finds out that there's been sexual harassment going on. But the point here is, even if she doesn't tell somebody right away, as like the Harris Farms case or like the Willamette Tree case, it doesn't mean that she's lying. All of these things may be forms of retaliation that may chill her out. So just because she doesn't report it promptly doesn't mean it's not going to result in a finding. Retaliation is one of those powerful tools to chill out people, and it itself is a separate cause of action. So sometimes it may mean termination, demotion, or threats otherwise intended to chill out the charging party. If that happens, we can get relief for that too. So a classic case is the Windermere Realty case, where Maureen Little was raped by a third party who the company was trying to get a contract with, and she complains to her supervisors that she can't work on this contract anymore because she believes she was raped by the customer. And the company says, well, we don't want to hear about that, and if you can't continue working on the contract, you might as well clear out your desk, which is what they did in Windermere Realty. And the Ninth Circuit of Appeal says the company can be liable for third-party rape and retaliation. You should know, in this case, Windermere Realty was trying to place employees of another company in temporary housing. The person who did the rape was the human resources director of Starbucks. Retaliation rests on the notion that you can engage in protected activity, that is, you can oppose discrimination and you should not be deterred about it. So if you complain about discrimination, threaten to file a charge, etc., that's protected activity. In Crawford versus Metropolitan Authority, Ms. Crawford and two other women were fired after they had participated in a company-initiated internal investigation of harassment by a manager. And although they themselves had not filed charges of discrimination or complained, they did describe the sexual acts that the supervisor had done upon them, exposing himself or propositioning them for sex, etc. And the Supreme Court said their description of the repugnant behavior reflected their opposition to harassment, and therefore their activity was protected, and the termination of them by the Metropolitan Authority constituted unlawful retaliation. You should know that the harasser there was the Director of Employee Relations. So aside from participating in protected activity, we have to show that there's some link to the charge of complaint, that the termination was linked somehow to the activity, and that's usually not that hard to show. Usually it's a question of timing, that it happens very quickly. In our Fry's case, just settled last summer, Mr. Lamb, a supervisor, was fired within 2 weeks after he reported the harassment of a young Latina woman who was working in sales. She herself also joined the lawsuit, and we recovered $2.3 million for them. I'm going to be moving quickly since we're cutting out of time. So the remedies that we have, we can get people their jobs back, get them hired, promotions, etc. Try to get training in a company, hopefully get no rehiring of discriminating officials. And then the real remedy for many of these cases is compensatory damages. That's money for pain and suffering, emotional distress. And again, we're going to use the same evidence in part that we use to establish liability. We can also get punitive damages for punishing the employer. The courts can order that. In EEOC versus Harris Farms, we were able to get a punitive damage award that was very significant, and the court upheld it, saying that the company here had shown basically reckless disregard in handling the complaints of Olivia Tamayo. In the ADA, so that's more or less on sexual harassment, but the ADA may be implicated in some of these sexual assault, domestic violence cases. One initially is that we can't treat people differently or unlawfully or harass them because they have an impairment, actual or perceived impairment. And this may be impairments that come from domestic violence or dating violence or sexual assault. So for an example, an employer searches an applicant's name online, learns that she has a complaining witness in a rape prosecution, and now she's depressed. And so the employer may say, well, you know, I don't think I want to take you on in my workplace because you're going to be absent for work so many times because of depression. And so they basically say, I'm not going to hire you. That may be unlawful discrimination. In this other example, we have somebody who's a victim of facial scarring, in part because of the domestic violence. She tries to come back to work, and you know, the rest of the staff makes kind of abusive comments about her because of her skin graft scars and so forth, and the manager fails to take any action to stop the harassment. The employer might be liable because the harassment is based on her facial disfigurement, and that's covered by the Americans with Disabilities Act. And also, if somebody is indeed disabled, the employer might be required to provide a reasonable accommodation. So this can include a whole variety of things, but mainly it's to make sure that the person can do his or her job if they are disabled. So this could mean things like changing things in the workplace, perhaps her work schedule, maybe some modified furniture, maybe her you know, something has been impaired for her that she may need some adjustments with a computer and so forth. All of these things are reasonable accommodations that can allow somebody to perform his or her job. And the employer has a duty. It's not just, you know, at their own discretion. It's mandatory. ADA mandates that an employer provide a reasonable accommodation if somebody is disabled and they need it so that he or she can do his job. So, more classic example is when somebody doesn't have any sick leave and they're not covered by the FMLA. The employer says, well, you know, I'm not going to give you any leave here because I guess I have to apply it the same way to everybody else. And what I want to note here is that the FMLA is completely different from the ADA, so that if she is disabled, or, you know, in a variety of reasons, depression included, following a sexual assault, it may be that the employer has to give her some time off so that she can, you know, perform her job later on. But that's a simple, reasonable accommodation that the employer can provide. In this other example, we have a situation where the employee has been stalked by her boyfriend, and they work, you know, in the same location. She may request assignment to an available vacant position, or he's separated and the employer says, no, I'm not going to provide this accommodation, citing it has a no transfer policy. Well, this would be unlawful because the employer should be able to reassign the employee, either her or the other employee. My preference is the harasser should be changed to another workstation or work schedule so that she can continue working. The ADA also prohibits disclosure of confidential medical information. So an employer is not supposed to discuss the medical history, condition of any employee. It can only be discussed with supervisors who basically need to know. If you're being treated for PTSD, they can request accommodation, but if the employer talks to others about a medical condition, that might be a violation, only to people who need to know. Again, like Title VII, the ADA prohibits retaliation. So, just to know for briefly, all the services we provide are free. Our process is fairly straightforward. We take a complaint, we'll investigate, we'll make a finding. We do give the parties an option to mediate in some situations. If we make a finding called reasonable cause, and then we'll conciliate the case, which is an informal negotiation between the employer and the commission. And if we settle it there, then the matter remains confidential. If we decide that the money offered by the company is too small, the matter would then come to the regional attorney like me, and I'll decide should we sue the company or not. If we make a finding of no discrimination, then we would basically give the employee a notice of right to sue. So just some final tips. Work with us. We'll partner with you. I have a whole lot of materials on how to work and collaborate with the EEOC. You know, if you are aware of any of these issues, contact us immediately. We have a lot of resources available, and then feel free to contact me directly. You can email me. You can contact our district offices, and we also have offices in Seattle, Oakland, and San Jose. So, Erica, let me turn it back to you.
Thank you so very much.
Are we handling up questions, or?
Yeah, sorry. Thank you so very much, Bill, for all of the information that you provided today. It's incredibly rich and dense, too. There's a lot of information there. So I know that some folks had a handful of questions. If you have the time, Bill, maybe we could just address a couple of them before we jump off. So one person asked, what kind of employer? In other words, how many employees do they need to have in order for the ADA to apply?
They have to have 15 or more employees during 20 weeks of a calendar year.
Mm-hmm. Okay. And earlier, somebody had asked, how many domestic violence cases has the EEOC been involved in? Do you know?
I don't have a direct number on the number of domestic violence cases that we've been handling. I would say, my sense is, because this is a relatively newer project for us to look at this, it's not been that many yet, and we're just really starting our real outreach and education on this topic. Generally, the cases we've been getting is sexual assault by a co-employee or supervisor, but not one where, say, it translates from the home to later. Our office has only litigated 2 or 3 cases with these kind of fact patterns, at least since I've been here.
Yeah. That same person had also asked, how would the EEOC treat the denial of a reasonable accommodation for domestic violence? For example, changing a phone number or location of the office when there's no comparable situation not involving domestic violence and no employer policy on point.
Okay, so remember the ADA kicks in if she's suffering from a disability, period. If it came from domestic violence, doesn't matter. If she has a disability which requires some kind of accommodation, then we could look at it. If the reasonable accommodation she requests is, please give me another number, a work number, that seems reasonable, and it's, but it's not. You see, I think what we're distinguishing is a temporary restraining order kind of situation, or protecting her from the violence. Well, the court would say, well, what is her disability? If her disability is depression, PTSD, something like that, and then help her so that she could do her job because of her disability, and it would require, say, changing her phone number, changing her work schedule, then that might be reasonable for the employer to do that. But we have to tie it to a disability.
Okay, great. That's very helpful. Yeah, similarly, somebody else is asking about whether someone who's raped and suffers some sort of mental health disability, are they considered to be disabled under the ADA?
Again, it's a case-by-case matter, but if, you know, she alleges she's got PTSD or depression, the employer has a right to ask, could we get some medical documentation on that? And if a doctor verifies it, the employer should be granting that reasonable accommodation.
Okay. So it's mental health is covered as well as
yes, mental disabilities, physical disabilities, all covered. Law makes no distinction.
Great. Let's see. I'm going to try and figure out what this. I'm not certain that I'm understanding this question. This is from Holly. So is there any time frame you have to file sexual harassment? I had someone tell me they tried to file a report, and the attorney told them it was past 185 days for the filing of the report. The client is no longer working at this place.
Okay, so the general rule is it's 180 days. But in states that have a Fair Employment and Housing Agency, the law is amended so that there's 300 days allowed to file a charge. But there are certain states, for example, like Alabama, that has no Fair Employment and Housing Agency, and so the statute says you have to file your claim within 180 days with the EEOC. Now, however, as I pointed out in the Willamette Tree case, if the reason why she missed her deadline is because the employer has deterred her through trauma, physical harm, etc., that might excuse her missing the deadline.
Okay. Someone else is just asking for a citation for the Fuller versus City of Oakland case.
I don't have it.
If you don't have it now, we can distribute.
You can send. Yeah, I mean, you can just get off Westlaw or
okay.
something like that. Yeah.
Great. I'm not seeing other questions right now.
Yeah, I see.
Oh, there's.
Is there another one about Veronica?
Yeah, one just came up. Yeah. So, what can an employee who reported sexual assault by a supervisor do if an investigation was started by HR at her place of employment, but she's being treated differently, meaning she feels like she is being discriminated by her coworkers?
Okay, then I would say she'd do two things. She would go back and complain to Human Resources that she feels like she's being discriminated against or by her coworkers. The employer could be liable for this further discrimination or harassment by coworkers because it knew or should have known that she's being treated differently. And she should still be coming to the EEOC to file a charge. Even if she's filed an internal complaint, she should still come to the EEOC to file a charge.
Okay, great. Oh, and somebody kindly posted the citation for the Fuller case.
Oh, great. Thank you.
Yes, the PowerPoint will be available as long as Bill's okay with it. The PowerPoint will be available through our website.
Sure, that's fine. That's fine.
Okay.
Please contact us. And when, my advice is better to contact us than not. Don't say, don't think, we won't answer this because of so-and-so. It's better just to call and let us decide whether it's something we can handle or not.
Okay. Well, thanks everyone for your questions. I really want to give a huge thank you to Bill Tamayo for your excellent presentation and all of this information.
You're welcome, and thank you to all of you for your important work that you do for victims.
Mm-hmm. Thank you also to Lynn Rosenthal at the White House for encouraging us to pull these pieces together for today's program and for this to be part of the Equal Futures Partnership. We're thrilled to be part of it, so thank you so much, Lynn, for your leadership over there. And lastly, thanks to the Office on Violence Against Women for providing us with the funds to sponsor today's webinar and programs like it in the future. We'll be sending out, you should be having access to an evaluation form about today's program. If you can complete that after the webinar is signed off. And if there are further questions, please don't hesitate to get in touch with us or Bill directly. Thank you so much for all of your work.